Good afternoon. Thank you for attending. My name is Dan Pouts. I'm a trial attorney here in our Syracuse office. Today, we're talking about everybody's favorite topic, litigation avoidance. As rational people, when we hear the term litigation or trial, we panic, and that's a natural reaction for good reason. Litigation can be time-consuming, it can be expensive, and it's filled with uncertainty. So while the chance of litigation is always going to be a risk that we're going to deal with in our business, the good news is that there's ways in which that risk can be minimized. As you're going to hear today, there's no hard and fast rule. If there were, the five of us that are here today would all be without a job. But, you know, as I tell my clients often, the good news about our system of justice is anybody can sue anyone for anything. That's also the bad news. There's no question that we live in a heavily litigious society, for better or for worse. So what we decided today was to assemble a few of very knowledgeable and experienced litigators to educate us about some of the common pitfalls or oversights that can lead to litigation, as well as some various ways in which the risk of litigation can be minimized. Before we get into that, I want to address a couple of housekeeping issues. The first is, although we're doing this through a computer screen, as always, we want to keep this as interactive as possible. So throughout the course of the presentation, you'll notice over on the right side of your screen, if it looks like my screen, there's a chat feature. So I'm going to be closely monitoring that. So please feel free to put your questions in there. And that if there's an opportunity, either during the presentation or at the conclusion, if we have time, I'll throw the question out there to the respective presenter, and hopefully we'll get your question answered. The good news is if we don't address your question today during the presentation, we're going to provide contact information for all of us. So, you know, please do not hesitate afterwards to follow up with one of us. Let us know your question. We're here to help, and hopefully we can all work through it together. So without further ado, our first two presenters are Ryan Kelleher and Mara Afzali, both of whom are seasoned commercial litigators out in our Albany office. Ryan's going to talk a little bit about what steps need to be taken once it becomes apparent that litigation is imminent. And then, since a majority of the cases that we handle as commercial litigators involve contracts, Mara's going to walk us through, you know, how contractual issues arise in these cases and provide a little bit of insight as to the way in which, you know, we can address these issues at the outset and how courts interpret the various contract-related issues. So without further ado, Ryan and Mara, please take it.
Thanks, Dan. And I want to echo your comments, thanking everybody for attending today, taking off their lunch to listen to this important topic, as Dan indicated. To get started with mine, I think a lot of people think that when a lawsuit or litigation starts once you've been served with a summons and complaint. And unfortunately, this is just not true. Preparation for litigation starts well before the complaint. In fact, it should start as soon as you have notice that there may be a potential lawsuit. The most obvious sign that a litigation is imminent is a demand letter. So you may be asking yourself, well, what is a demand letter? Well, a demand letter typically comes from a lawyer, and it briefly outlines the dispute at issue, the request for some money or some other action that must be taken place to resolve the matter. And then there's usually some sort of threat of litigation or reservation of rights in order to bring litigation or something like that if the demand is not satisfied. These are usually pretty short letters, and they are pretty obvious for those who know what they're looking for. The problem is a lot of the times these letters come to your company and they may be received by an assistant or somebody who's not really familiar with the legal process, or maybe it's somebody in your mailroom that's just not even looking at the content of it at all. So once a demand letter has been received, we have some key takeaways for that process. So the first one is who to notify. As I indicated before, a lot of the times these letters come in and they can get tossed aside, they can get thrown out, or they just don't get to the right person. So I think a key takeaway here is to notify a proper person. And in order to notify a proper person, we have to identify that proper person. So in your company, whether it's the president or CEO or another C-level person, or maybe that person shouldn't be bothered with this, then there should be somebody in your organization that is identified as the person where, whether it's a demand letter whether it's a phone call from an attorney or it's in fact a summons and complaint, that these documents get to one individual and they don't just get thrown aside or that type of thing. I can tell you in all my experience, a lot of the times when we're getting these cases where there's default judgments, meaning a defendant failed to answer, it's because the complaint ended up not getting in the right hands of somebody in the organization. Well, the same thing goes for the demand letter. So let's make sure that we have somebody in our organization that is identified, or a group of people that are identified to get that demand letter. So now that you got the demand letter, it's in your company, it's in the right person's hands. Now, where do you go with that? Well, we should always be getting these demand letters to our attorneys. So whether that's your general counsel, your in-house counsel that is right within your company, or if you have outside counsel such as Schoeneck King that does your legal work, whether it's litigation legal work or something else, we're here to help, we're here to assist. And no matter what it is, you got to get these demand letters to lawyers, because most of the time these demand letters have time frames. So for instance, the letter may say, please respond within 10 or 14 business days or days or date from the date of the letter. And if not, then they may move forward with the lawsuit. I think the key here is that you want to make sure that the person in your organization has notice, your lawyers have notice, and there's a response to that demand letter in order to avoid a summons and complaint being filed. As Dan indicated, that we are in a litigious society and lawyers are not afraid to bring cases. So the key here is when you have the demand letter is essentially saying, hey, heads up, we might be bringing a lawsuit against you. Well, the key is to let's get that contacted with the other attorney, and let's make sure we can see if that can get resolved so we don't have a suit that's filed against us. Who else should be notified? Well, this is also very important. You should notify your insurance carrier. Now, with many of these commercial litigation cases, which are mostly contracts, a lot of times the insurance companies may not pick up coverage for it. However, you never know until you get that demand letter and obviously a summons and complaint to the insurance carrier. A lot of the times the insurance carriers have notice provisions in their policies. And if you don't get these letters to them, then they could disclaim coverage. And that's obviously not what you want to happen. Another thing that could happen is the insurance carrier may actually cover this loss. And the earlier you can get them involved, then the sooner you'll get a decision as to whether they're covering it. And if they do, they will actually hire an outside counsel to represent you. It could be bond still, or it may be somebody that they choose. But either way, the sooner they assign that lawyer to defend you, the less legal fees you'll have to be spending, the less pressure you have, and so on and so forth. So it's incredibly important to get your insurance carrier involved right from the get-go, even if you don't think they'll cover it. You never know. Another key takeaway here is act fast. I know I've kind of touched on that already, but you want to act very fast. You want to get it to the right people as soon as possible. Number one, so they know how to deal with it, but number two, so you can contact that other side. And lastly, you want to preserve documents. This is something I'm going to get into a little bit more in a few minutes, but preservation is key. Okay, so you received the demand letter, you notified the proper people, including your attorney, and you preserve documents. So now what are the potential outcomes? Well, there's a few different things that can occur. So the first thing is having your attorney contact the other side and seeing if this is something that can get resolved. Many times this is something that can get resolved and your attorneys can work it out and reach a resolution. So that way you don't have to get sued. You don't have to worry about the next steps on that. You don't have to worry about attorney's fees and being tied up in a lawsuit for 3 or 4 years. If this is something where you resolve it without attorneys, or you have your general counsel inside your company resolve it, which does happen from time to time, I would encourage you still to reach out to your outside attorneys for preparing and reviewing the settlement documents. There are a number of settlement documents that need to be prepared. And if they're not done so properly, or they're not done so at all, then this could come back and haunt you in the future. And in fact, even if you sign a release, it might be too narrow that you might be settling something thinking that all of the disputes are resolved, but then 3 months later you get sued because the release didn't cover this, that, or the other thing. So it's very important that you get a hold of us, have us either prepare those settlement documents, or if you're doing them internally, have us review them give us a second shot at it to look at it, make sure everything is there. So if the matter can't be resolved at the demand letter stage, then there's two things that could occur. One, you could do nothing and call their bluff. And sometimes this is very effective. If you think that the other side just doesn't have the money, or they're not in a position to sue, or if they're coming upon a statute of limitations or something like that, in some ways it's better just to do nothing and see what happens. This isn't the most common situation, but it is a situation. Then the next thing that you could do is, obviously, if you can't get it resolved, then you may have an action filed, and then you got to contact your attorney to defend that suit. If an action is filed, then that always triggers your duty to preserve documents. So I touched on this briefly before, which is preservation. Well, if you're served with a summons and complaint, you must preserve documents at that point. Really, you should be preserving them right when you have notice of the dispute or an issue or the demand letter. But if you're served with a summons and complaint, that absolutely triggers that duty. Other things that could trigger that duty, one, we've already talked about the demand letter, but also a call from the opposing attorney. If you're getting a telephone call from an opposing attorney saying, hey, I have a client here, they have a dispute with your company, blah, 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 that would also trigger a duty to preserve. In rare cases, there's what's called pre-suit discovery, meaning the court has allowed the attorneys to conduct some discovery on the set of facts, or to obtain some documents, maybe an on-site inspection, or in rare cases, a deposition, to gather some information in order to bring a lawsuit in the future. This certainly would trigger that duty as well. The good practice is, if there's any dispute, accident, event, or anything else that could lead to a lawsuit, make sure these preservation measures are put into place. So to many of you, preservation measures may mean absolutely nothing. So what do I mean by that? Well, once the duty to preserve is triggered, generally a party must do two things. So the first thing is, you're going to want to suspend your routine document retention and destruction policy. So again, that might mean nothing to you as well, but it will mean a lot to your IT department, or those individuals that are dealing with your emails. So for instance, as an example, with your emails, a lot of times companies have expungement policies. So this is the time where you want to remove those expungement, for at least for those particular custodians of those documents. If it's a smaller company, I would just suspend the expungement policies for the entire company, everyone's emails. And then secondly, you're going to want to put in what's called a litigation hold. Essentially, it's a letter that's sent out to those custodians or those individuals at your company that may be involved in the retention of the documents. They may be actually individuals that are involved in the potential lawsuit, or they have knowledge of the lawsuit. And this is something, as your attorneys, we would send out a litigation hold letter. A lot of times your in-house or general counsel may do so as well. We typically send one even if one's already been put in place. So what is the scope of your duty to preserve? And a lot of times companies get really open-eyed with this, and they don't know where to even go with this. Well, the key here is, it's a very liberal standard. So preserve anything and everything that is relevant or potentially relevant. Err on the side of caution and just preserve the documents, the emails, the text messages, social media, what have you. A lot of people forget, this is an important point here, is that a lot of people forget that a lot of people, especially now after COVID, are working from home. They may be using personal computers or phones or other devices, or even social media. Those things need to be preserved as well. It's not just documents and information on your work computers. And I think the key takeaway here is, always involve your attorneys in this process. It could, like I said before, it can be daunting, it can be overwhelming. We can work with your IT department, your general counsel, your HR, or whoever else is involved, the custodians, to make sure that these documents are preserved. And it's very important to preserve these documents.
Ryan, thanks. That's really helpful. As you were going through the end of the presentation there, something occurred to me that, not to be all doom and gloom, although that's sometimes what we deal with here. What, if any, are the potential consequences for not preserving this information or this documentation, as you just suggested?
Well, Dan, thanks for that question. And that's a really good point. And this could be a whole hour presentation in and of itself just on this topic. I will get into a few here. I know we have limited time, but if you have any further questions on this topic, please shout out to me or Dan or whoever else is on this presentation about this, because it is important. But to quickly answer your question, well, number one, documents that you're preserving might not just be helpful to the other party, but they might actually be helpful to your own party. So the first thing is you might be losing documents that could be helpful to your case or could win your case, could help you win a motion for summary judgment. That's the reason why we want to preserve it for our side. In order to preserve for the other side and to prevent any negative consequences for that situation, is there's something called spoliation. And I'm not going to get into all the elements and what have you, but essentially that is not something we want to deal with as lawyers. It's essentially saying that these documents or equipment or contracts or what have you existed. They now don't exist. And because of it, the court is going to take action. And the court could take action with respect to an adverse jury instruction. And while that may mean nothing to you now, when you're at the end of a trial and the judge is reading jury instructions, that could be the difference between winning and losing a trial. And if there's a negative jury instruction in there because documents were deleted or expunged or what have you, you could literally have all the facts in your case and potentially lose the case because of that jury instruction. Some of the other possible sanctions, just to summarize here and quickly end this topic, is striking claims or defenses. So if you have some affirmative defenses that could win you the case, those could be stricken from your case, from your answer, and now you lose even if all the facts are on your side. Evidence could be excluded. There could be monetary sanctions, and depending on how the documents were expunged, there could even be some contempt orders. So, these sanctions can be extremely harmful to you. And again, it's very important to get your attorneys involved right from the get-go, right from the time you have notice of this, it could be a demand letter, and make sure this litigation hold is in place and all the custodians are aware of the documents that they need to preserve.
Brian, thanks so much. That was a ton of information and really, really helpful. Appreciate that. Transitioning now to Mara, as we talked, as Ryan mentioned, and as we talked at the outset, most of the commercial matters, the majority of the commercial matters that we handle involve some type of contracts, whether it's an allegation of a breach of contract or, written contract, oral contract. There's a ton of different legal issues that come up around contractual relationships. So we have Mara here today. Mara, can you tell us a little bit about some of these issues that come up in the contract world in terms of litigation?
Thanks, Dan. Yes. So when people think of a contract, they might initially imagine the typed up document, which lays out the agreement. There's a bunch of legalese in there, wherefore clauses, and then both parties sign at the end of the document. And in fact, that is what a lot of contracts look like. But contracts can also take on a lot of other forms. As Dan mentioned, under New York law, a contract can also be formed orally. And also you want to look to sometimes more informal documents that can form a contract, such as invoices or service agreements that you might not be looking at through that contractual lens necessarily. So the classic example that they have of this that all lawyers learn about is a case in from the 1950s where two neighbors run into each other at the bar. One wants to buy the other one's farm, and after they have a few drinks, they take the bar receipt and write on the back, "I, property owner, agree to sell my land to my neighbor for $50,000. And that, in fact, was upheld as a contract by the court because it had all the key terms and key aspects of a contract, which are, there's an agreement. It's between at least two parties, and each of those parties gave something up in order to get something back from the other party. And they both agreed to the same key terms. Right here, it would be the price and the specific farm. So there's a very simple example of something that you might not think would be enforceable that in fact was enforced. And so, it's obviously not quite that simple. There's some types of contracts that the law requires to be written under a doctrine that we have called the Statute of Fraud. So those would be more high stakes contracts or real estate contracts contracts for the sale of goods over $500 and other types of contracts. So, it can get a little bit more complicated, but the takeaway there is just that there are things that you may not be thinking about that are in fact enforceable under contract law. And of course, there's times when parties intend to enter into a formal contract. So maybe you start emailing back and forth draft proposals or agreements, and then, they pick up the phone and they're hammering out those last couple terms, and they, end up agreeing to move forward and, say, you're hiring someone to start pouring concrete at a site, and they end up agreeing to say, okay, yeah, I like that last draft you sent over. Go ahead, come over in the morning, get your crew to start working. And the crew starts working and they're performing under that contract. Well, maybe they didn't realize that they never went back and actually signed the contract or actually determined which of those drafts was the one that governed. They didn't put that part in writing, but now they have a piece of paper that does lay out the terms, but it can get a little bit more complicated in those instances. So, is it the contract terms that apply? Did they add additional terms while they were on the phone with one another? And there you have a problem where everybody thinks everything's going to go well. Of course, we all want at the beginning of when we enter into an agreement for things to go well, but it doesn't always end up that way. And that's where things can get a little bit complicated. So again, a lot of times these disputes or common problems that come up that we see a lot in our litigation department arise from either a misunderstanding about those terms or what the exact agreement was, or maybe a misinterpretation or a different interpretation of what one party was supposed to do or the other party was supposed to do under the contract. And when courts are looking at the contract and interpreting those terms, what they're trying to look to is where the parties had what they call a meeting of the minds, or where they did agree on the same terms so that the court can enforce that. So when you have a clean written document that's properly drafted, the court's going to look to that document because that's where the parties put their agreement down. They said this is the complete agreement, and that's what the court's going to enforce. But again, when you have those documents that aren't signed, or where there's additional oral agreements and other invoices and other types of things that go along with it, it gets more complicated for the court to determine. And some of the issues that can come up are when one party maybe mistakenly believes, for example, that they're going to be able to get a certain supply that they're going to need to perform under the contract. And, we all know with the supply chain issues going on right now, maybe they were wrong, they were mistaken. And there you have an issue where they thought they could perform, and by something out of their control, they couldn't perform. Or perhaps another thing that the court might look to is, how are the parties behaving? What is their conduct? So they may have said they were going to do X, but now they're doing Y, and everyone agreed to it. Maybe the other party cashed a check that was sent, and that's going to be interpreted by a court as an acceptance of the work and performance that was going on. And then another thing that comes up is, we look to the terms, and like Dan said, if we could avoid all litigation, then we'd be out of a job. But often, when we're looking at these contracts and we're trying our best to make sure that the parties have the same understanding of what a certain term or word or phrase might mean, but then you get to the end, of a dispute and it goes to litigation, and all of a sudden the parties are fighting over a specific word or phrase and the meaning. Is it a vague term? Is there some ambiguity in that term? And that's something that comes up a lot as well. And so that's why, when we're looking at it, we say, you expect the best, as I mentioned, but also plan for the worst. And that doesn't mean that the contract, isn't going to go well, but you want to be making sure that you're covering all your bases to plan for the worst, with that eye towards, obviously not wanting to be in a litigation and avoiding that litigation, but also being prepared and having things be as clear as possible should something end up going into a litigation or a dispute. And that's something that really happens before, Ryan was talking about when you get that demand letter. Well, this is something that's really, yes, at that point, call us, get that demand letter into the right hands. But taking a step back, if you can have a litigator's set of eyes on things at the drafting stage or at the reviewing stage, a lot of those problems can be avoided as well.
Mara, thank you so much. That was great stuff. Again, if there's any questions or any issues that either Ryan or Mara brought up, please feel free to reach out to them directly. Moving along, we're going to move west here, and we're fortunate to have Steve Sharkey with us this afternoon. Steve's located in our Buffalo office. He's the deputy chair of our firm's litigation department as well. Very well known, very respected commercial litigator out in Western New York, and has a tremendous amount of experience handling contract-related lawsuits, the type of matters that Mara just touched on. So Steve is here to give us some additional insight and some key thoughts or key issues to think about. So Steve, thank you for being with us. Please take it away whenever you're ready.
Okay. Thank you, Dan. And good afternoon, everyone. I'd like to keep moving along here, and I'm going to build on a little bit of what Mara was talking about. She was talking a little bit about formation of contracts and issues that you encounter. I'm going to talk about issues that you may have with existing contracts and how we can help you with those. You may ask yourself, why are some of these provisions important? I can tell you they're important because they can have a dramatic, if not determinative, impact on litigation that you may find yourselves in. And it's issues that we see on a daily basis in all of our cases, because as Dan mentioned, contracts really form the large portion of the cases that we see and handle. So we're going to talk about some of those provisions that we see and that are germane to you and your business. And the first is jurisdictional provisions. I'm sure many of you have heard the term jurisdiction, maybe not sure what it is. Jurisdiction is nothing more than a court's ability to hear a case by the parties before them. Jurisdiction is something that you can control in a contract because the last thing you want to do is get into a lawsuit with somebody and find out that the court says you don't have the right to sue the party you've sued in the court in which you've sued it. And this is especially true in situations where you're dealing with people from perhaps other states or even other countries. And this could be a real problem for you, and it's something that you can rectify with a jurisdictional provision. Say, for example, I'm a Western New York company that makes products, and I sell them to, I contract with a party in the state of Washington, and I sell them $50,000 worth of products, and they stiff me on the bill. I'm going to want to sue them, if possible, right here in Western New York, where I'm located, as opposed to the state of Washington. And with the right verbiage and drafting, you can create a provision in your contracts that specifies at the outset that in the event the parties ever get into a dispute, New York would be the controlling jurisdiction. You can say, for example, I can agree that the parties consent to jurisdiction of any disputes over the contract in the state of New York. And I can give you a real world example where this becomes important. I had a client once that is involved in environmental materials, and he contracted with a party in the state of Louisiana. And a dispute arose between them as to payment for some of those materials. And ultimately, it ended up in a lawsuit. And that lawsuit was brought in the state of Louisiana because, unbeknownst to me, he had entered into a contract with this party, and that contract specified not only that the case could be heard in the state of Louisiana, but it was controlled by Louisiana law. And I will tell you that proved extremely problematic for this client because he had to hire lawyers down there, and quite frankly, it resulted in a result that may not have happened had the issue been sued here in New York. And so he was at a tremendous disadvantage. And it's something that you can easily control with the stroke of a pen in your contracts. Another provision is venue. And venue sort of goes hand in hand with jurisdiction. Venue is more which court or venue or forum, if you will you bring the case within a particular jurisdiction. For example, you can specify that any dispute between the parties will be brought in a federal or state court located in the county of Erie, which is where I'm located. There's a lot of advantages to doing that. Number one, it's essentially you're creating home court advantage. You can have the dispute here locally with judges that you're familiar with, lawyers that you hire. Those lawyers are familiar with the judiciary and the local bar. And quite frankly, you can save yourself a lot of money. I think something like that is important where you're dealing with people, say, from like upstate New York and downstate New York. Again, if you're a company that's either in central or western New York, you don't necessarily want to litigate your dispute with another party down in New York City, where the courts and frankly the expenses are much greater. So you can save yourselves a lot of money, a lot of trouble and headaches at the outset if you incorporate provisions like that into your contracts, which specify that those disputes will be heard, wherever you're located. Another provision that's extremely important in any contract, and frankly, if you take anything away from the presentation today and what I'm telling you, this is probably the most important thing, is an attorney's fee provision. A lot of clients don't understand this, and I get asked this on almost every case I've ever had, is that under what is known as the American rule, ordinarily, unless you have a statute or contract entitling you to an award of attorney's fees, you are not entitled to your attorney's fees in the event you prevail in a lawsuit. And that's extremely important because attorney's fees, unfortunately, become a big factor into litigation and whether or not you settle them. So if you can, and you should have an opportunity to flip this rule by inserting an attorney's fee provision in your contracts, which specifies that in the event that you prevail in a lawsuit, you're entitled to your attorney's fees. This is something that's important because it provides a strong deterrent against weaker claims. A lot of times people feel that they can file a lawsuit and, well, if we try and we don't succeed, oh well. But if you have an attorney's provision, I think that really gets them to think twice about that, because potentially not only will they be paying their own legal fees in this lawsuit, they could be paying yours as well. So it's extremely important provision, and it's something that I certainly recommend that everybody has in their contracts. Another important provision is a limitation of damages. You've probably heard about various damages before: consequential damages, punitive damages. Believe me, plaintiffs' lawyers are extremely creative in terms of coming up with damages in ways that they can maximize their clients' cases. And I will tell you, as a litigator, as I'm sure others on this panel will, these what are considered direct damages or indirect damages are very problematic because they can be a large amount, and they can also be difficult to quantify and defend against. Like we talked before, this is a way that you can incorporate a provision in your contract that restricts or outright eliminates damages from the outset of the case. And you can do this essentially for just about anything in New York, except for instances of gross negligence or recklessness. So you can agree, for example, at the outset of a contract to eliminate consequential damages, punitive damages, exemplary damages, delayed damages, and things like that. And these are types of damages that aren't readily clear sometimes. Like, say, for example, I have a product that I sell to a manufacturer that they incorporate in their machines. And because I'm unable to provide that product to them, their whole machine operation shut down. Now, all of a sudden, their business is stalled, and they may try to come after you for things like business interruption loss and things like that. Whereas all they ever originally contracted with you for was to buy this one product. And now they want to sue you for millions of dollars for the business that they lost. So again, this is the type of thing that you can incorporate in your contracts to eliminate that scenario. And I think it will make you in a much stronger position if there's ever a dispute between those parties. You can even specify specific damages in a contract in the event there's a breach, and provided that there's something that it's difficult to quantify. These are also known as liquidated damages. So there's a lot of things you can do depending on your business and the circumstances. But again, this is another thing we recommend everyone does if possible in their contracts, because it will save you a lot of trouble down the road. Another important provision in contracts is ADR, alternative dispute resolution. I'm sure a lot of you have heard of this and likely even participated in it. But an alternative dispute resolution is a way to provide some procedures in a contract which provide alternative means to the court systems to resolve your disputes. You can, for example, specify that the parties have a face-to-face meeting to try to resolve their differences before they file suit. And I think the principle there is there's some studies suggest that oftentimes when people disagree, if you can get them in the room and they share some common ground, perhaps they can work it out, and it eliminates the need for it. Another thing is mediation. Mediation is a similar informal attempt to settle the case, although you do that through a neutral third party known as a mediator, and you work towards achieving a resolution. And you can specify that that's something that must be done before filing suit. And lastly, arbitration. Arbitration is essentially an alternative to a lawsuit where the parties agree that you go before some neutral party, typically a lawyer, maybe experienced in that area, who will listen to the dispute and render a determination on the dispute without the need to go to the court system. And the theory being that it's quicker, more economical to do so. These are all things that you can specify in your contract. And frankly, you can specify even so far as limiting in an arbitration clause the use of class action claims. So there are a lot of advantages to that for you in terms of future disputes and in limiting those. So that's another very important provision. Another one is choice of law. Again, this kind of pertains more towards situations where you have parties from different states, but I can tell you it happens all the time. And oftentimes there may be confusion over which state's law is governing because everybody's got arguments about why their state is the most important nexus to the dispute between the parties, but you can eliminate all that at the outset. And you can specify, the parties can agree at the outset that this dispute or any issues that ever arise on that contract will be governed by a particular court or law rather. And here it's typically New York, since that's where we practice. And that's something that are enforceable and something that you should consider as well. Another important provision in contracts are statute of limitations. I'm sure many of you are familiar with statute of limitations, essentially a cutoff period in which parties can even bring suit. And if they fall beyond that period, the case is dismissed at the outset without ever getting into the merits. They're extremely helpful to sort of ferret out old stale claims. And for example, in New York State, the statute of limitations for breach of contract claims is 6 years, which is a very long period. And I think most people would find that if I entered into a contract and I got into a little spat with somebody 5.5 years ago and they suddenly sue me, that's not something I think people are readily expecting or anticipating. So there are ways that you can limit that and reduce that by contract. For example, you could even limit it down to 2 years if the parties agree, and those are typically held to be enforceable. Just an excellent way to provide a little clarity and certainty in terms of the cases and claims that you may have to deal with. There are a number of other important provisions. I'm not going to go into great detail, but certain provisions I think everybody should keep an eye on, such as confidentiality. There are certain common law confidentiality provisions that apply in certain scenarios with employees, et cetera. But you're always better off bolstering the protection of, say, for example, if you have proprietary or confidential information you don't want getting out in the public, that's something that you can incorporate into your contracts with your employees or third parties. So in the event there's ever a dispute between the parties, those materials don't suddenly become public knowledge, because if there's a lawsuit filed someday and they attach a copy of some sensitive documents, and that's a public record, anybody can have access to it, including your competitors and others that you may not necessarily want to see that. So again, this is another important provision that I think you should consider and have in any contract. Another one is indemnification. Indemnification is essentially the ability to pass off any liability you may have because you're being sued as a result of the actions of this other party that you're dealing with. And they're very common, usually typically in construction settings, but healthcare settings, et cetera. There's quite a few scenarios where, but depending on your circumstances, that's another avenue where you could potentially pass off your liability to a third party and have them foot the bill for the costs of your defense of an action. And it's something that we look for in contracts, and they come up time and again. And it's something that frankly can benefit you a great deal in the event you're ever in a lawsuit. Another thing is insurance. You can specify certain insurance requirements that must be had. You can have them name you as an additional insured on their policies. Again, this is another way to foot the bill for somebody else for lawsuits that you're brought in for. And it's something that is fairly easy to do. And again, some of that depends on your business relationship and the scenario involved, but it's another thing that we commonly see and do. Another great one that I'll talk just briefly about, because I know Brad's going to be speaking about this in a moment, is non-compete provisions and non-solicitation provisions. These are particularly important in certain industries and businesses with your employees, where you spend a great deal of money training them and teaching them the ropes and giving them access to information. You don't want them to be able to go out and then turn around and use that against you in the future with a competitor or competing business. So that's another provision. Brad's obviously going to speak more. That's a very detailed topic in and of itself. The last thing I would just say is, hey, this is something that we can help you with. Obviously, everybody has contracts that they deal with on a daily basis in your business, whether it's with suppliers, employees, third parties that you're contracting with. We often work with our clients and review those contracts for some of these very issues we talked about, and then sort of tailor the language in some of those contracts to more favor you and protect you in future lawsuits. These types of things can help you be proactive and attempt to avoid litigation, or at least minimize the impact of it in the event you ever find yourself in litigation. I think it also substantially strengthens your position in any future lawsuit that you might find yourself in. And finally, it really saves you a lot of time, energy, and costs and headaches, frankly, by doing something like that. I mean, I like to think of it as a sort of a legal physical, just like you go to the doctor every few years, have somebody come in, take a look at your contracts, see if there's any little minor things that you can take care of before they become big problems down the road. So that's about the end of my section. And I don't know if there's any questions, Dan, that came through.
Thank you, Steve. That was really helpful. And again, I mean, to hammer home the point, I think an ounce of prevention on the front end is worth a lot. And we as litigators and as business attorneys can get involved in the front end and hopefully help you to avoid these things. So last and certainly not least, we have Brad Hoppy, who's also out in our Buffalo office. Brad has become the go-to person, certainly in upstate New York, with respect to matters involving trade secrets and non-compete agreements that Steve just mentioned. So this afternoon, Brad has been gracious enough to join us and talk about some of the steps you can take to protect your company's trade secrets and confidential information. So take it away, Brad.
Thanks, Dan. And to echo everyone else, thanks to everyone for joining us this afternoon. The topic I'm going to cover today is ways to protect your trade secret information, from the company insiders, from your employees, from partners, from those who, just by virtue of their position, have access to some of your most valuable assets. And it's a threat that is substantial. It's a threat that's very real. I have some statistics that kind of back that up. Number one, I mean, you're seeing more and more trade secret cases being filed both in state and federal court. They're increasing on an exponential basis, decade by decade, and it's only gotten more prevalent since the Defend Trade Secrets Act was enacted back in 2016. Some of the statistics are just staggering when it comes to your company insiders. There was one study that was published that a bunch of former employees asking them whether or not they've taken information with them when they move to a new employer. 59% of those employees admit to having taken information with them. And of those, 67 admit to actually using that information in their new employment. I mean, that's shocking. I mean, these are the ones who are honest. Imagine just, what the real number is. When you look at trade secret cases, in both federal and state courts, the vast majority, 95% of them, involve those company insiders. So, I mean, this is a very serious issue and one that businesses should be aware of. But how do you prevent it? And that's what we want to talk a little bit about today. And it's a common theme that we've talked about throughout. You need to be proactive. We see it all the time. A lot of businesses would rather bury their heads in the sand and hope that it will not happen to them. But the statistics are pretty clear. I mean, if it hasn't happened to you already, it's likely to happen to you at some point in the future. So you need to be prepared. And that's why we recommend that all clients have a trade secret audit done. And I'm not going to go into great detail about what a trade secret audit is, but I just want to identify just a few things that we recommend that you do to protect your information and better position yourself in the event of a theft. Number one, you need to have your policies and procedures looked at. Just a few items that I just want to highlight on that. You need to make sure that access is granted only to those employees and insiders who actually need the information. The need to know basis. You need to make sure your digital and physical security is up to date and best practices are followed. You need to make sure that you're either limiting or eliminating access to personal cloud accounts. I like to call these USBs in the sky because you can access the information on a cloud account from anywhere, from any device. And that's scary when it comes to your information. But one of the biggest things when it comes to a trade secret audit or protecting your information at all is the use of contracts. That's another common theme you've heard today. I mean, there's ways that you can protect your information simply by including certain provisions in your agreements. And that's what I want to spend the rest of my time on today. When you're talking about, agreements in the context of trade secrets, you're talking about your non-disclosure agreements. You're talking about your non-competes. You're talking about your non-solicits. And these restrictive covenants can be either the best or the worst means to achieve trade secret protection. And by that, I mean, if you do them right, if you make sure that they comply with the existing state of the law, you don't utilize a one-size-fits-all approach, you routinely update your covenants, they're a very powerful tool at your disposal. But on the other hand, if you use the same agreement for all employees, if you use stale agreements that are 5, 10, 15 years old, and frankly, they're not worth the paper that they're written on. And it's even worse than that. I mean, they give you a false sense of security. They make you believe you have protection when in reality, the moment it's tested, you don't. And that's a scary proposition. So I guess that leads me into the next part of my presentation. It's, are your covenants enforceable? The first step to any analysis when you're dealing with a contract is whether there's consideration, to support that agreement. And when it comes to non-competes, pretty much everything is fact specific. There are no bright line rules. But one thing that does seem fairly consistent across states is that initial employment provides sufficient consideration for your non-competes. There's a good way to do it, though. There's a bad way to do it. I would recommend that you don't just drop a non-compete on an employee's lap on day one. You want to give them advance notice. Give them an opportunity to review it with an attorney if need be, so that you remove an argument down the road that they didn't know what they were signing or that they were coerced. The next thing for consideration would be, continued employment. This is more controversial. It's disfavored in the law, but in New York, at least, it's still recognized as sufficient consideration for a non-compete. That being said, because it is disfavored, we do recommend utilizing other forms of consideration for your non-competes. And those other forms would include things like, promotion, a pay raise. Any positive change in the conditions of employment can give rise to consideration for a non-compete. Use that to your advantage. If you're going to give someone a pay raise, condition it on a non-compete. And one thing that I think that everyone, not everyone, but a lot of people have this misconception that, you could buy yourself longer restrictions by paying more in consideration. And that's not the case at all. What matters when you're dealing with consideration is whether or not it's sufficient. And then once it's sufficient, you move on to the rule of reasonableness. And that's what I'll talk about briefly next. So the general rule for enforcement for a non-compete is that it must be reasonable in time and in area and no broader than necessary to protect a legitimate interest under the law. The first part, duration. No bright line rule, again, like everything having to do with non-competes, but 2 years is generally speaking okay. There's going to be situations where that's too long. The geographic area for your non-compete, again, very fact specific. It's going to depend on the footprint of your business. It's going to depend on the employee and what type of responsibilities that employee had. There's going to be situations where an international non-compete is fine. There's going to be situations where a 20-mile radius is overbroad. So that's why you need to talk to an attorney and make sure what you're doing is consistent with the law. The next part of that test is a legitimate interest. There are 3 recognized in the state of New York. The first is protection of confidential information and trade secrets. The second is customer relationships and goodwill. But keep in mind the no broader than necessary test. When you're dealing with a customer non-solicit, it can't extend to all customers. That's too broad. It has to be limited to the customers with whom the employee developed a relationship or obtained information concerning. So that's just one thing to keep in mind, with your non-solicits. The other legitimate interest is the unique employee. There's not much of a test for this. It has to be someone who's virtually irreplaceable. My rule is if you're relying on a unique employee as a way to enforce your covenant, you're probably in bad shape. You want to be relying on confidential information or trade secrets or your customer goodwill. All right, so what happens if you have an overbroad covenant? There are 2 things that can happen. One, and this I think is when you're very lucky these days. The court can say, all right, I'm going to give you the benefit of the doubt. I understand what you're trying to accomplish here. I'm going to partially enforce your covenant. I'm only going to strike out what is overbroad and enforce the rest consistent with the understanding and expectations of the parties. That used to be the rule in the state of New York. That's not the rule anymore. That's not the trend. The trend is, what I like to call the nightmare scenario, where a court says, employer, you controlled that non-compete. You drafted it. You forced it on that employee. I'm not going to give you the benefit of the doubt. Instead, I'm going to strike the whole thing. And that leaves you in a situation where your information is exposed. It leaves you in a situation where your relationships and goodwill are exposed. And that's obviously not where you want to be. So you need to make sure to update your agreements. You need to make sure that you're complying with the existing state of the law, not the law 5 years ago. So that requires you to look at these on an annual basis. It requires you to make sure that you're up to date and you're not relying on stale agreements that were good 5 years ago but may not be now. But there is one good thing to keep in mind when it comes to these non-competes and an overbroad covenant. You can fix them. There is still time. There is still hope. And I talked about consideration earlier. It's kind of the same list. You could fix your non-competes in the same way. If you have an employee that's up for a promotion and they're subject to a non-compete that might be old, use that as an opportunity to put a new covenant in front of that employee, one that's consistent with the law. Same with any positive change in the conditions of employment. And the last one is severance. If you're terminating an employee and would otherwise provide them severance, use that as an opportunity to get a non-compete that's enforceable and one that could actually protect your information. Now, I know we're getting close to 1 o'clock here, so I'm going to cut it off. But there's certainly a lot more to talk about when it comes to trade secret protection. There's certainly a lot more to talk about when it comes to your covenants and making sure they're consistent with the law. Please feel free to reach out to me or anyone here on this call, and I'm sure we could answer any questions you might have about trade secret protection and non-competes.
Brad, thank you so much. That's hugely helpful. So we it's 12:57, so we've kind of hit the end of our time. What we're going to do is you'll get an email from us with all of the presenters' contact information, probably later on today, along with the survey that we asked that you submit your thoughts on how we did today, how we can do better, and maybe some additional topics of concern or interest that you'd like us to present on in the future. So thank you again for joining us. We appreciate you making the time. And to the extent that we can be helpful at all, please feel free to reach out to us, and hopefully we'll see you on a future webinar. So thank you again.